dignitaries, there's so many eminent lawyers have expressed their views, given their valuable thoughts on this legal knowledge. This process is really amazing, and I sincerely thank to all of you for all the efforts you people are taking. Thanks for the coordinators. So I guess I'm already late. Let us begin. I'm supposed to speak on this topic today. There are 4 topics which I'm supposed to address. I'm supposed to speak on art of examination in chief, art of cross-examination. Third thing is things to keep in mind while examining a witness, and importance of eyewitness and medical reports. Before starting, I would sincerely ask all of you a favor. It might happen that after in the question answer session, I may not be aware of the answer. If something is asked to me, sometimes I may not be sure, or I may be I may need little clarity, or I may know, but I may not be able to explain. In that case, please bear with me. Just drop email or a message. I would surely get back to you. Another thing is, while delivering a lecture right now, I might use short forms or the common language which is normally used in court in day-to-day life. So it may not be very polished and articulate. I just want to convey the things I just want to convey you people. So please bear with me to that extent. So let us start. Cross-examination is truly an art. Some advocates we see, they are actually God-gifted. The way they cross-examine, it's no less than a concert sometimes when it comes to. Everybody is not that God-gifted. Surely we need to work on it. So what should we bear in mind while cross-examining witness? First of all, quite obviously, hard work. We need to be very thorough. We need to be dedicated to the process of working on the brief, working on this criminal trial. Basically, cross-examination needs one very solid thing, that is your common sense. What you need to do is put your foot in the shoe of that witness. What a person will think, what a person is. When you understand the witness, it's quite easy to cross-examine him. Take a situation wherein, suppose there is some eyewitness, a person who is witnessing some ghastly incidents. What a person will do in that case? What will be his conduct? What will be his logic? What will be his demeanor? How he'll respond to it? Will he try to stop that incident? Whom he'll inform at the first in time? These are the things one should bear in mind while cross-examining that witness. If somebody is claiming to be eyewitness, if there is any discrepancy, if there is any loophole in there, that someone is claiming to be eyewitness, but it can be seen that he has not immediately told this about this incident to anyone. There is time gap. So it can be clearly gathered that there is some problem with the witness. Either he is not eyewitness or there is something else the story is. So this is basic of it while examining the witness, understanding the person basically, and applying logic. Cross-examination starts always with this. When we speak about cross-examination of a witness, there are usually two things, as we all know. There is examination in chief, and there is cross-examination, and again there is re-examination. As we all know, even the section, it is section 137 of CRPC, this examining a witness. Who starts with examination in chief? Very obviously, the party who calls the witness. The party is that lawyer starts with this examination in chief. Quite obviously, this is not necessarily always public prosecutor. Quite a lot, whenever it comes to the defense witness, when defense lawyer is calling the witness, quite obviously the examination in chief is conducted by the defense lawyer. Very importantly, now here, when we speak about examination in chief, we all know, it should be always be borne in mind that no leading questions are permitted in examination in chief. So what do you mean by leading questions? Leading questions are such questions wherein you are leading the answer. If suppose, for example, the situation is, suppose A stabs B, if this is a situation. What you should do is, you are not supposed to ask any such question that would lead the answer, who stabbed B. You are initially, prior to the examination in chief, a lawyer who is conducting this examination in chief, he is to make aware, he has to make the witness very much aware with the statement what he has given, and now he'll have to conduct the examination in chief. Usually it is presumed that the role of the lawyer conducting examination in chief is just to ask the question, what happens further? It is not true. It's not necessarily only he should refrain himself from asking any other question. If suppose the witness is forgetting something, then the situation should be such that he should.
Ma'am, please unmute your. Yes, ma'am, you're unmuted now.
Yes. He'll have to take the situation in control and make the things in such a manner, put the things in such a manner that the witness will remember the things. If suppose there is incidents wherein, suppose there is eyewitness to a murder, take a case, take it. Let us take example of this situation. One person has witnessed the murder. What he tries is, he tries to stop it. He's not successful. Then he runs, he tells the incidents to somebody else. And then he tries to tell this to somebody else. He comes back to the scene of incidents. Some people gather there. He's telling this to others. Then he's trying to carry the injured person in a vehicle. So this is the situation. What happens is, initially the person who is in the who has put to examination chief, he's telling that he witnessed the incident, he tried to stop it, but he forgot in the examination in chief to tell this to depose before the court that he told this incident to somebody else. Now what the lawyer should do here? He cannot ask any leading question. What he can do here is, he'll try to the witness to remember what happened then, without asking any leading question. Usually what happens is, any other question other than what happens next, if this is put by the lawyer who is conducting examination in chief, this is considered as leading question. It is not true. Leading question is somewhat different from the questions asked normally. Normally the questions asked, they're permitted. So one should be very well aware of this fact, that only leading questions are not allowed. Rest all other questions which will help the witness to depose before the court, all such questions are allowed, and they should surely put before they should surely be asked to the witness. What will happen if examination at the time of examination in chief, if the lawyer is asking leading question in the examination in chief, what will be the result of this? Very obviously, this is hazardous for the sole reason that the testimony, that the deposition wherein leading question is put, that is not considered. So you are losing a very vital piece of evidence there. So this is the result. One should surely try and avoid such kind of questions, asking leading questions. A very well-known a case of Varki Joseph is known for this fate of examination in chief. When a leading question is asked and the answer which is recorded like, this is true to say. But at the time of final argument, if this is pointed out as leading question, so you're losing this piece of evidence. What is the role of defense lawyer here? This is a little out of turn, quite obviously, but I would like to point out even this, because this will help when we are talking about cross-examination as well. Objection should be raised here by defense lawyer if any leading question is put. If objection is not raised, then quite obviously court is recording this in this manner, that this is true to say that this certain situation is there. Give me a moment, I'm so sorry. Defense lawyer should try and persuade the court not to take this kind of leading question on record. Court itself should not take this question on record. And despite of that, if this kind of questions come, this kind of questions asked, and if the answer is on record, surely this cannot be considered as a piece of evidence. So quite obviously, leading questions, they are allowed only for defense, not for prosecution witness. What will happen if the witness is in the witness box and he's not supporting your story, as in the story of the party who is before the court, the story of the party whom he is witness to before the court? So quite obviously he is in usually he's termed as hostile witness, that is he's resigning from his statement. So permission should be taken by the lawyer to cross-examine the witness by declaring him hostile. And in that case, leading questions can be asked, every sort of questions can be asked. Re-examination is taken, and in that manner, the witness is permitted to cross-examine as normally he would have been cross-examined. When we speak of cross-examination, when we speak of art of cross-examination, this is quite obviously very powerful weapon which is used to falsify the defense of a witness. When we speak of cross-examination, and when we speak that cross-examination is an art, what should we think while cross-examining? First of all, we should master the facts. When the cross-examination starts, is it after the examination in chief of the witness? No. Is it when you receive the charge sheet? Ideally, it should be prior to that. The preparation of cross-examination starts even prior to the charge sheet. When we can say that, when we are saying that preparation of cross-examination starts even prior to the charge sheet, quite obviously, there is any evidence which is supporting to the accused, say plea of alibi, or any telephonic conversation, or if there is any tower location, any such thing which is there to prove his innocence, this should be brought on the record as early as possible, and they should be used in the cross-examination. This is part of criminal trial, but this is again out of context, but let me take a moment and elaborate this. When we think of cross-examination, this is not limited only to a witness. This is always interconnected, interlooped to all other witnesses. You build a story there, right? So when you have defense, even this should be developed at the time of cross-examining the witnesses. Again, taking one more minute here. This is again part of criminal trial. I'm very sure you people are aware of it, or this must be already on record. Prior to this must be conveyed to you by some other eminent dignitary. But let me take a moment and tell you this, that whenever there is some record which is favoring you, as I said, be it telephone conversation, be it messages, be it WhatsApp messages, be it tower location, that gets wiped off after a few days. So we should try and make an endeavor to to make an application to the court to preserve the record. We can go under section 91, and we should try and hold it for your further defense. This should be done as early as possible. This surely helps in cross-examination. When I say that cross-examination is not, it should not refrain only to one witness, that there is a chief examination and then subsequently you are thinking of a cross-examination. This should not happen. The reason is you try to falsify the case of the witness, and this can be helped with the statement, previous statement of other witnesses as well. Take a case of suppose under section 27, there is a case of recovery. Witness is deposing, the prosecution is taking benefit of this recovery. If any other witness is deposing in such a manner that already he has disclosed this, that there was knowledge of this fact, that the weapon, he had seen the weapon, or he had seen, for example, the dead body. If anywhere that has come on record, so we should take benefit of it. Anything that take a case, take another example. If suppose someone is claiming to be eyewitness, quite obviously, earliest disclosure is very much necessary for to make him trustworthy. But say he has deposed the fact that he has deposed this thing about he is having knowledge of this incident after some 4 or 5 days, and he's coming up with a case that he was not available, he was not there. If suppose any other witness in his either previous statement or his depositions, if he's stating that that particular person was there, he was accompanying, so we should take benefit of this. Quite obviously, the credibility of that witness goes away. This kind of things, when especially Panchanama and recovery Panchanama or any such thing, any person who is claiming to be Panch and he's claiming that he's not interested witness, if his name comes in any other statement of any other statement of any other witness, quite obviously he is interested witness. So he being Panch, his credibility is questionable there. Again, while cross-examination, one must be thorough with the charge sheet. In a sense, timings of Panchanama, they are to be taken into account. Many times they are goofed up. Many times the timings are problematic. We should consider that the spot of Panchanama and the spot and the police station, the distance is quite far away. But timings are given such that they reached in a stipulated time, which is practically not possible. So just one single witness, one single deposition before the court and cross-examining him is not the thing. Thorough knowledge, thorough reading of documentary evidence, of medical evidence, of deposition of other witnesses, statements of other witnesses, every possible evidence that comes before the court, every possible evidence that one should be very, very thorough with while examining the witness. Again, one more thing comes here in, one more thing is very important. The charge sheet is provided to the accused, but going through only charge sheet is not sufficient. One should always make an endeavor to check the copy of court records. The reason being, the copy supplied to the accused, the charge sheet supplied to the accused is quite obviously the photocopy. Sometimes in Panchanama or sometimes in documentary evidence, there is overwriting, either overwriting or there is change in the ink, other pen is used. You can see such record which is original when the documents are original. You can see from the court record. So always one should make sure that you are checking the original documents of the court. Sometimes even that happens inadvertently, quite obviously, but certain documents or maybe transcripts, these things are sometimes not supplied to the accused. The copy is with court only. So prior to taking the defense, even this is very important. Prior to cross-examining, this is also very important to check the record of the court prior to even cross-examining. Another very important thing, when we speak about art of cross-examination, the things we should consider at the time of cross-examination, quite obviously not more than that, but still at least equivalent to or at par, one should be acquainted with the basic knowledge of the things needed for cross-examination. For example, medically, one should be really sound. One should be really thorough with the anatomy. One should know the basic forensics. Even handwriting expert, when we cross handwriting experts, anything which is coming before you, be it finance, any expert you need to cross-examine. Prior to cross-examining that expert, one should seek help of the experts, get one's fact basically correctly, and then only we need to cross-examine. If suppose there is a case of, if suppose prosecution is coming up with a case of hanging and defense is claiming it to be strangulation, then quite obviously one should be very well aware of the difference, the ligature marks, the things they need to differentiate between hanging and strangulation. So quite obviously, at the time of cross-examining doctor, this should be very much clear in mind what exactly you need to ask. So you should be thorough with it. Since the beginning, always taking experts' opinion at the time of preparation, this is very much needed. This is how you keep growing, I guess. This is how you keep your knowledge updated. And very obviously, at the time of cross-examining any witness who is expert, you have to have knowledge of it. Another very important thing is, at the time of cross-examining, when you put questions, you should be very careful what the court is recording. You're putting a suggestive question, or you're asking a leading question, you're asking a query. You should be very clear in your mind. It will be all right if the witness, if you're putting a question, if the witness answers in positive, it's very well and good. Quite obviously, this is going to benefit you people. But if the answer is coming negative, quite obviously, this is going to backfire. So better refrain from asking such questions. Why you should be more careful what court is recording, because this is the way you're developing your story, right? So what happens is, your question does not come on record. It is not shown in record. What is recorded is deposition by the witness. So while subsequently, when you read the depositions, then you understand what has happened. So when you're asking a query, but the court is recording in the suggestive form, so that becomes your story, which is quite fatal to you if you don't intend to do it. So this kind of questions you should bear in mind while asking, because very subtle difference whether when you ask the question starting whether or is it true, so likewise the answers will come. So quite obviously this is very important that you should have all ears to the court, what court is listening to, what court is understanding, and what court is recording. Here one more thing comes regarding cross-examination, that when you ask a question to the witness, witness is not answering to your question. Witness is taking liberty and answering something else. Witness is kind of diverting. And court is recording that kind of answer what witness is giving. So quite obviously, you should take objection there. Witness, you should try and limit the witness only to the question you have asked. Witness is supposed to answer only to the question you have asked. If witness is diverting, witness is giving some other answer, witness is volunteering, quite obviously this should be brought on the record immediately. This should be brought to the knowledge of the court very immediately. And you should surely try and request the court to take the answer that witness volunteers, saying the witness volunteers. Because as we all know, when witness is volunteering something, when it has a different meaning, it has a different weightage when we read the testimony in toto. So these are the things they should be kept in mind. If suppose the witness is volunteering, we are requesting the court to record it as witness volunteers, but court is not much keen to listen to you. Then one should request to the court saying that this should be taken in question and answer form. That court must record your question and then court must record answer of the witness. So at least this should be clear when we read the deposition finally, that what was the question asked by the lawyer and what is the answer given by the witness. Because what witness is deposing, that is not what you asked, that is not your story. So this should always be borne in mind that anything which is deposed in the court, whether you asked it, do you intend to ask it, take a pause, take a moment, and then think of what to ask. Here, one more thing is, if suppose witness has answered something which is not what you expect to, or which is immediate, which is fatal to you, probably. But still, you should not lose cool there. You should compose yourself, pause. You're not to change your body language. You're not to change your face. You're you should just be there. And again, try and ask the witness the question in such a way, again, when you have in your mind that what answer you need from this witness, what is the situation, why this person is witness, what he's intending to tell, and then again you should ask the question. Even though if some mishap happens in the court hall, you have asked something which is backfired, that is all right. You're not to lose cool. The moment you lose cool, you are again creating the hostile situation. This is not what is expected. One should always keep this in mind while cross-examining. One should be thorough again with this concepts of omission, contradiction, and improvements. They should be very properly brought on record. As we all know, I'm very sure this must be made quite well aware what is omission and what is contradiction and what is improvement. The fact which is stated by the witness before the court at the first time in examination in chief, which does not appear in the previous statements, that is called as omission. The fact stated before the court differently than the previous statements, that is called as contradictions. For example, take a situation wherein A stabs B and C holds his hands. If this is the situation, if witness says for the first time that A stabs B and D holds hand, so this is something he has not stated previously. Earlier the name was of C and now he's stating the name of D. So this is contradiction. This should be brought on record. Anything which is improved, there is a situation wherein A stabbed B, C caught hold of his hands, and D was standing there. If this is the situation, and if name of some other E comes into it, which is right now, which was not there previously. So this is quite obviously improvement. The name of involvement of E is improvement. So all these things, omissions, contradictions, improvement, they should be brought on record. This is very important for the thing that many times it happens that previous statements, they are one, witness quite obviously deposed before the court, which is the prime piece of evidence. So witness tries to improvise, witness tries to bring on record, which is not stated before the police, or which is not stated in any other previous statements. So this should be brought on record, quite obviously, as you all know, because that has a very less value than the original statement or the original version of the witness. So when we speak of omissions, when we speak of contradictions, when we speak of improvements, they should be timely brought on record to make sure that that removes all other extra stuff which is not stated in the previous statements, or which is stated for the first time before the court. Quite obviously, it has very less value in the testimony of the witness. Cross-examination should one more thing I just forgot regarding this omission and contradiction and improvement, or basically omission and contradiction. A well-known case law is of Tehsildar Singh. I guess you all must be knowing of it. This was reported in 1959, AIR 1012. Tehsildar Singh. This is a very well-known case law for omission and contradictions. Cross-examination should not be lengthy. It should be quite a precise counterpart of the examination in chief. What is asked in examination chief, one should focus more on that. Quite obviously, taking into consideration all other previous statements or all other evidence which is there. One should avoid unnecessary questions. Lengthy cross-examination does not serve any purpose. It should be to the point. One should always bear in mind what exactly is to be asked. Why? What is this witness is saying? Why this witness is there for? More we focus on this, more positive answers we get. Any question which is risky, we should think twice before asking. While cross-examining, another thing is one should understand temper of the witness. What kind of this person is, whether he's aggressive, whether he's docile, little mellow, he's aged, infirm, he's child witness, what kind of person he is. There are some witnesses who have this habit of giving answers in negative. The moment they step into the court hall, they feel that defense lawyer is our enemy, and whatever he's asking, we should answer in negative. So we can take help of this situation, this mentality. He's answering in negative, so you can put such questions which he's going to answer in negative, which will help you bringing presence of someone or removing presence of someone, stuff like that. So this can be helpful. One should understand temper of such kind of witnesses. This helps surely a lot in cross-examination. At that time, we should have very confident body language. A witness who is there in the court hall, quite obviously, he has actually witnessed it or who has not witnessed it. The moment he understands that the lawyer is very thorough with the facts, lawyer knows the facts so well that at that time, witness also tends to think twice before getting aggressive. A confident body language and precise mapping of questions, they really help a lot in cross-examination. When there is a case that defense witness is to be taken, there is scope of defense witness, either for plea of alibi or any other things. The foundation should be built at the very outset of the cross-examination of other witnesses. We should try and put the story since beginning. If we need to establish a presence of defense witness, or we need to establish evidence of some document, that should be in the suggestions or even the questions asked to the cross-examinations. This cannot happen that the prosecution witnesses, they are cross-examined and there is no story put to them in any manner, and all of a sudden defense is coming with the story and taking defense witness, wherein the presence of defense witness is not at all established in anywhere in the cross-examination. That is something which is not expected, that does not help much. So foundation of your defense, whatever defense you are taking, the story should be laid, the foundation should be laid at the very outset of cross-examination itself. Suppose, for example, one is taking the defense of grave and sudden provocation. There is a case wherein we find that medical reports are clear and clinching. Suppose take a case that there is a clear case of homicide. There are more than one stabs. If this is the case, there are eyewitness to it, or there is suppose medical reports to that effect. Quite obviously, this is a case of homicide. You hardly have any scope here. So what can be done is you have other possible defense available, which is either private defense or grave and sudden provocation. So one should try and build this kind of defense since the beginning. That was there any abuses given? Was there any quarrel prior to it? At least in suggestive form, or you are trying to take some defense witness for it. So this should be this should reveal thoroughly in the cross-examination of the earlier witnesses, those prosecution witnesses. Another very important point I would like to make here is usually it happens that when the criminal trial is at the concluding stage, we try and find out the case laws for our case. We try and find out the law points and all for the case. We should try and avoid this. Since the very beginning, we should check out the case laws. Since the very beginning, we should check out the law and the situation. It is very easy to build your case since beginning based on law. This is more easy. There are in case laws, reported judgments, there is some law on this point. Try and make case accordingly instead of after cross-examination is over of all the witnesses, and then you'll try and search. Then you'll try and search for the defense, or then you'll try and search to come out of the clinches of law. Better than that, this is always better that you try and build your case since beginning. There is no straitjacket formula for any kind of cross-examination, for the sole reason that every person is different. Situations are different. What we should focus more on what is to be brought on record. More importantly, I would suggest here that cross-examination is gain more of a patience rather than agitate the witness. Agitating the witness or making him hostile will serve no purpose. What is more important is one should not lose cool. One should be more patient. Focus on the answers, what you are expecting. There should be more focus on those answers, though they are expected, and then try and put the questions in such a manner that the witness will answer according to your situation. What do you want? One question, if it fails, again after a gap, after asking some other questions, try and put the question in another manner. Try and extract the answer instead of making him agitated and even the court hostile towards you because of the uh, because of the um, because the manner in which you are putting questions, you are actually making the court hall more you're putting the question in aggressive manner. You're making the situation more hostile towards you. More calm you are, more patient you are with the witness, with the situation, I guess that should help. When we speak about importance of eyewitness and medical reports, quite obviously we all know that eyewitness are a very important piece of evidence always. Even a sole eyewitness can bring conviction to the accused. Very obviously, the evidence should be clear and clinching and trustworthy. Even sole eyewitness is sufficient enough. Medical reports, when we speak about medical reports, they should be perused quite carefully. Let's speak about eyewitnesses first. While cross-examining the eyewitness, one should think that whether presence of that eyewitness was natural there. If somebody is claiming to be eyewitness at the spot of incident, is it natural that he was present there? For example, if there is quarrel in the field, if there is quarrel in the field and there is free fight in two groups, if some third person who is nearby in another field, it's quite natural that he can see the fight and he can run there and he can see the actual incident. But if some person who happens to be far away, his field happens to be far away, if he's claiming to be eyewitness, this is quite such suspicious that there was no reason for him to be there, then why he's there? Such kind of questions we should ask ourselves first while cross-examining, that any eyewitness who is claiming to be there, whether he happens to be natural eyewitness. Second thing, if he's interested eyewitness. We all know the value of interested eyewitness, what it is, an independent eyewitness. Quite obviously, independent eyewitness weigh far more than the interested eyewitness. What is the subsequent conduct of the eyewitness? When the incident was happening, what the eyewitness was doing, whether he was trying to prevent it, he was trying to inform somebody else, what exactly he was doing. There is many times this happens that eyewitness claims to be eyewitness, but he's standing there, he's not doing anything to stop. There is no sign that he tried to suppose free fight, he tried to prevent it. So such kind of eyewitnesses, they're quite easy to cross-examine for the sole reason that there are many lacunas, there are many loopholes in their statement. So when they're not natural, they're brought up eyewitnesses, this should be always borne in mind that what is the sequence of what is the sequence of the facts and what eyewitness is claiming to be there. Is there any delay in recording his statement? Is the delay logical? Is the delay properly explained? This should always be borne in mind. Is there any immediate disclosure, which is very important, quite obviously, because there is somebody's witnessing some ghastly incidents. Quite obviously, his first reaction will be he'll go and tell this to someone. Is there any such kind of disclosure? Is there any corroboration with his statement to other witnesses' statement? Even that is very important. When there are more than one eyewitness, there are 2 or 3 eyewitnesses, to their statements corroborate, is either story corroborating. This is also very important. Quite obviously, if suppose there is a dying declaration and there is an eyewitness as well, there should be corroboration. Is presence of that eyewitness can be seen in dying declaration. Even that is very important. Eyewitness is claiming to see the incident, but his name does not appear anywhere in dying declaration. As we all know, dying declaration cannot be cross-examined. So quite obviously, then his trustworthiness it can't be said that totally goes away, but quite obviously, it makes a lot of difference that his name does not appear in the dying declaration. All such things must be always at the time of cross-examining eyewitness. Again, it makes a lot of difference what kind of eyewitness he is, whether he's child eyewitness, whether he is old and infirm eyewitness. Their conduct will be quite obviously different. While examining eyewitness, especially child eyewitness or old and infirm eyewitness, consideration of court is also always different. So this should be always kept in mind. Instead of there, quite very obviously, if the witness is sly or if the witness is very aggressive, extracting truth from him is surely the duty of lawyer. But still, without making a child eyewitness hostile, it is more important to make an endeavor, make an effort to make them more comfortable. It so happens in the case that if they're not actual eyewitnesses, if they're brought up eyewitnesses, child witness is one of the best witness to be brought the truth from. Because once you make them very comfortable and once you start asking them questions, this is very easy that they get into the trance of actually speaking the truth, and they'll actually speak the truth. This kind of things one should surely remember at the time of cross-examination of eyewitnesses. Again here, one more thing I would like to suggest. When we see the importance of eyewitnesses, or while cross-examining, of course, one should make an effort to visit, to take the instructions by your own self. This is very important. Just one should not rely only upon the charge sheet, or one should not rely upon the information given by the relatives or any near and dear ones of the accused. Very importantly, the person who has gone through it, very importantly, the person who has actually suffered it, one should take first-hand information about the incident from that person only. He is the best person to give you information, and he is the best person to give you clear picture of the witnesses, whether they are eyewitness, whether they even the panchas, whether they were actually present at the spot of Panchanama, whether the Panchanama was prepared at the spot or in the police station, as we all know that happens, whether there is actually any recovery, or the recovery this is again cooked up recovery signed by the panchas in the police station, whether there actually any whatever happened, he is the best person to tell you this. So when you take instructions from the accused himself, this helps a lot in cross-examination. When, for example, suppose there is a case of recovery Panchanama, and the accused, there was no recovery. This is case made by the police. So now then you start thinking how to falsify the punch, how to take admissions from the punch when actually the person is not there, what mistakes he can commit. There may be mistakes of time, there may be mistakes of difference, there may be mistakes of identification of the weapon. All such questions, they surely pop up in your mind, and surely you are able to put the questions. This is how it helps. So try and take the instructions by your own self, which is very important at the time of cross-examination. When we speak of medical reports as well, what are the important things that one should keep in mind? Very importantly, what is the history given to the doctor first in time, which is very important. First in time, whatever as we all know, whatever comes first in time, whatever comes before the whatever is documented first in time, that is quite obviously very important. So many times this happens that suppose there is some assault, and the history of assault is given by the victim as assaulted by unknown persons, and subsequently he is naming the accused person, subsequently names of some other persons are arrayed. So this is important at the time of cross-examination of doctor. This should be borne in mind. Even witnesses. If suppose here the history is given that assault by unknown persons, and there are subsequent eyewitnesses who are claiming that they witnessed the incident and there were persons who had assaulted. So there is discrepancy. This is how it should be tackled with. This is how it should be borne in mind. One should always check from the medical reports or the papers there before the court, or papers in the charge sheet, that whether any such statement was given to doctor which can be subsequently treated as dying declaration. If suppose the victim, or if suppose the person who is assaulted, or if suppose the person any bodily injury is done to him, has he told anything to the doctor subsequently which can be treated as dying declaration, which may not be on the record? So this should be extracted. This should be gathered from the papers which are before the court or which are in the charge sheet. Sometimes it happens that the history given to the doctor is that injury by stick, and subsequently it is claimed that the injury is by axe. The blow is given by the axe. So there is difference in the age of injury. There is difference in the nature of injury. This should be always borne in mind. So before cross-examining doctor, or before cross-examining IO or any other witnesses, one should go thoroughly with the medical papers. One more thing which is very important, that if medical papers state something very positively, if the result is very clear and clinching, then you should take the defense accordingly. There is no point in falsifying those kind of medical papers, because doctor or any medico is not a person who is interested. They are not interested witnesses. There is no reason for them to depose any false testimony. If they are saying that this is homicidal death, then there is no point in questioning their trustworthiness. Then one should develop the defense accordingly. What can be at the max done here? One should, first of all, one should develop that defense accordingly. What can be done is one should check whether there is any alternative defense available. For example, there is blow on head. The case is there is a blow on head. What one can at the max do is there any possibility that such kind of injury is possible by fall on the stone? If some person is at the height of some 3-4 feet, and if he's falling on stone, if his head is falling on stone, is there any possibility of having such kind of injury? So this is alternative defense what one can build. Or take a case wherein suppose there is a case that it is claimed that the person was given a blow on his head and subsequently he was burned. So one should check that one should put a question to the doctor in such a manner that is there any possibility of getting the skull cracked or getting the skull fractured due to heat, which is absolutely possible. So accepting the medical papers as it is, what one can do is one can try and build another defense. First of all, accept it is, try and build your defense, try and build an alternative defense, but one cannot totally falsify the medical evidence. One cannot totally falsify the doctor here. Same is the case at the time, even there are cases of 376. History given to doctor is something else. Injury, nature of injuries are somewhat else, and the testimony is something again different. So this should be always borne in mind that what exactly is right now before the court, what is there in the charge sheet, what defense can be taken, what is to be kept in mind at the time of cross-examination. So this is how I would like to sum up. One should always keep in mind, first of all, what uh, what defense is available, taking into consideration the law points, taking into consideration the case laws, what are the facts, what are the depositions, what are the previous statements, what are the documentary evidences. One should try and build defense on basis of all these facts. In addition to this, without agitating witnesses, how to extract best possible answers, what are actually beneficial to us. If anything is backfiring, quite obviously this is quite wise to leave it there and try and ask some other things which can be brought on record or which can be benefited. So these are the basic of art of cross-examination, examination in chief. These are the basic things one should keep in mind at the time of cross-examining or at the time of building your defense. These are the basic things regarding eyewitnesses and keeping in mind medical reports at the time of cross-examining. So here I conclude my session. Thank you so much.
Madam, when should
Thank you so much, ma'am. Thank you for the wonderful sessions. Now I request the participants, the floor is open for the question answer. You can unmute yourself and ask the question.
Excuse me, ma'am. Good evening, ma'am. Is it audible, ma'am?
Yes.
Yeah. Suppose if a lady has been brutally hit by someone, okay, but physically mark is not there, not inside also, means he tried to kill him through but the physically mark is not there, not internal damage and all. And he went to the registered medical practitioner, and practitioner said that it's not any kind of case. Like means suppose sometime somebody wanted to keep a gas open, try to burn them. So in that cases, how to defend them? Means
to defend the witness, the victim, or to the accused? Victim. See, there are two different things. First of all, attempt to, right? Attempt to, actual act done, isn't it? You know that, I guess. So when it is coming to attempt to, quite obviously the situation is different. And when actual act done, the situation is different. Take a case, what you are stating right now, that if somebody tried to burn the lady by opening up the gas, there is no physical mark on the person of the lady. So there is attempt made. It is not necessary that there will be physical mark on her person. Other things, what are actually done there? If suppose there is smell of gas,
yes,
right? There is some witness to it who can depose that the witness smelled the gas. If any other sign, if suppose here take a case that kerosene was put on her person, she was not set days, but there was kerosene on her person. So there will be something to show her sari or her clothes, they are soaked in kerosene. So they are quite evident that the attempt was made.
So actually, what was happened? Sorry to interrupt you in between, ma'am. Actually, the police has came. It has been called to 112. Police came. They smelled it also, and after that, lady went to the thana also, and he explained, but they have not lodged under the 307 attempt to the murder. Okay, and the medical has been also done. Medical has been.
Yes. Please continue.
She went to the hospital also to doing all the things, but there was no physical marks and all. Means normal thing was there, and it has been not lodged. So now the proceeding goes on in the court. So in that case, how that thing will be getting proved, or how that attempt to murder has been proved, it has to means, because police will generally, it is happenings. These cases are generally, police will not listen and things will move like that. So in that cases, how to defend them?
You always have court's door open, sir. In that case, you can lodge private complaint. You can go before the court of GMFC. Whatever evidence you have, you can present before the court of GMFC. They'll order police to investigate the case. So whatever evidence you have, quite obviously there is no physical mark, but other evidence, whatever you have, you can put before the court of GMFC. So you always have option open of lodging a private complaint, which goes before the court. Not even though FIR is not registered, but there are n number of cases wherein the aggrieved party appears before the court, coming up with the evidence what they have, and subsequently the FIR is registered. So you always have that option open.
And FIR has been done, ma'am. They have not done the sections.
Even the police is not registering FIR. Even the police is not registering FIR. What you can do is you can approach the court of judicial magistrate with your own evidence.
Okay.
In a private complaint. They'll look into it.
So it is private complaint means just application. We just need to write and give it to magistrate.
No.
And how
that is again in the format that goes before the court. Court looks into the evidence what you have, and if the evidence is sufficient enough to make out the case in the facts you are stating. If suppose this is a case of attempt to murder, if coming up with the case with whatever evidence you have, then what happens is, in that case, the judicial magistrate, the learned judge, he'll direct the police to look into the facts and register the offense accordingly. So this has happened. This is the common remedy which is availed. So this happens many times, and successfully it is availed actually by so many of the victims.
Okay.
In case of a domestic violence, there is no witness available to the woman, so
Yes.
they find the difficulty to prove it.
Yes.
So how to help them?
Yes, sir. Actually, in the cases of domestic violence, or in the cases of any violence to the woman which happens in the four corner of the house, in the four walls of the house, the consideration is different in that case. Usually, in any other criminal matter, it happens that strict proof of evidence is needed. Sufficient witnesses or sufficient material is needed. But in the domestic case, it is always considered by the law that there cannot be any witness to it. If suppose husband is beating wife daily in the house, quite obviously you cannot expect that she should bring some witness. So in that case, testimony of wife is more important, is given more weightage to, provided there should be clear collaboration of her statement to the other facts. For example, she is saying that I narrated this incident to my neighbor.
Okay.
For example, she's saying this, or she is disclosing this fact to some of her friends. There should be a clear collaboration between these kind of statements. This is not necessary that she should bring some direct evidence or some direct eyewitness to this case. To this case, sometimes even it may happen that she was beaten, but she was not taken to the hospital immediately. So after 2-3 days, even the age of injury, or even quite obviously the day when fresh wounds are different, after some 2-3 days they might fade away.
Normally,
Any evidence connecting to the actual happening, connecting to the facts, they are considered in the case of domestic violence.
yeah, if injury is there, because
A little liberty is given there actually.
Right.
So this is happening.
even if they tell their parents that I am suffering, that is also taken into account.
Yes, that is surely taken into account. Sir,
Sir,
in criminal trial, anything which is disclosed first in time, it has more weightage and more than anything else.
Okay, got your point.
If suppose if a person is, if the victim, if the lady is coming up with the case that something happened to me and she's disclosing this after 6 months, quite obviously that won't have that much effect if she's disclosing this immediately. So basic consideration before the law, actually.
Okay.
Yeah, so shall we just wind up this session, ma'am, as we are running short on time?
Thank you so much. I hope this satisfies the basic queries or the basic gist of the topics they were given to me. Anything else? Even if subsequently anybody else is having some query, surely just drop a mail. I'll positively get back to the person.
Yeah, yeah, thank you so much, ma'am.
Thank
So
you so much, Timmy.
yeah, so I just wrap up the session. Thank you so much, Mrs. Ghanekar, for this enlightening session. I'm sure everybody would have found your insights and expertise valuable and informative. I also would like to thank all the participants for being cooperative during the session and appreciate your participation and engagement. Thank you all for joining.
Thank you. Thank you so much.